Senator Brownsberger.
Madam President, over the past too many months, federal agents have brutalized people on the streets across the country. No police necessity can explain their excessive use of force, which has shocked and disgusted fair-minded people across the political spectrum. In the absence of a federal administration willing to hold its agents accountable when they depart from constitutional norms, states need to impose liability and make court-ordered relief available. The pending legislation includes universal 1983 language, which will fill a gap in civil rights protection. I wish to make some remarks clarifying our legislative intention regarding this language. As background, excessive use of force by officers, that is, persons acting under color of law, constitutes a violation of civil rights secured by the Fourth Amendment of the Constitution. Victims of unjustified official violence are often able to sue under a federal statute that dates back to the Reconstruction era that followed the Civil War. That statute, now known as Section 1983, allows lawsuits seeking redress for deprivations of constitutional rights by anyone acting under color of state law. Section 1983 targets agents acting under color of state law because Congress was seeking to protect freed people from the depredations of racist officers in former slave states. It does not cover violations of rights by federal officers. The proposed language here tracks the language of 1983, but will create liability for violations of the United States Constitution by any officer acting under color of law, whether state or federal. The proposed language applies equally to local, state, and federal officers. However, it has the effect of creating new liability only for federal officers. The proposed act will not alter the liability of state and local police officers because they are already subject to liability for violations of the United States Constitution under Section 1983, and the proposed act will preserve all the defenses available to officers sued under Section 1983, including so-called qualified immunity. Qualified immunity protects officers from civil liability for action that does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. However, qualified immunity offers no protection for officers using unreasonable force. It is well established that the police may not use unreasonable force in typical circumstances. Like lawsuits under Section 1983, lawsuits under the new act may be brought in state or federal court, although they're likely to be finally resolved in federal court. It is worth noting several limitations of the proposed language. First, it does not create liability for violations of the Massachusetts Constitution. Doing so might violate federal supremacy principles. Second, it does not create liability for violations of federal statutes. Congress, as it creates statutes, makes implicit or explicit decisions about whether and how to create liability for violations of those statutes. We in the state legislature cannot override those decisions. Third, the proposed act does not target, the proposed language does not target immigration officers. It applies equally to all federal officers. It does not interfere with federal decisions about law enforcement priorities. And lastly, just a quick note about personal jurisdiction. Personal jurisdiction will be governed, as for other causes of action, by a combination of statute and case law. General Laws, Chapter 223A, Section 3, grants personal jurisdiction over persons causing tortious injury by an act or omission in this Commonwealth. Constitutional violations are tortious within the purposes of this language. Thank you, Madam President. Those are the remarks I wish to make.